This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
Now we're plugged in, we're ready to answer questions. Okay, so first question. What is the best way to bring up an overworked community manager with the management company? We have worked with the community manager before at another company. Okay, so what we say that you do, ask for a meeting with the CEO, president, immediate supervisor, whoever it is, mention your concerns. If you like the manager, tell them you like the manager, because if you are going directly to the CEO or the president, odds are they will think immediately of, do I need to replace this person? Do I need to move them to another association? So if you like your manager, make sure that you say that. Because then maybe there's just some work that we can do to address the issues that you're having, and you can keep the manager you like while improving the work provided. I'll say this, if you feel like they have too many properties, tell the CEO or tell the manager, because they do give them a lot of properties. Some of your managers are managing they have so many balls in the air. They have so many associations, and every association is so different. Their needs are different. And quite frankly, the amount that they have to work with the boards are different. I can certainly attest to this. There are some boards that are very hands off, and there are some boards that really do want you to kind of hold their hand through the process. And it's possible that your manager has a couple of those boards in addition to you. So make sure that you tell the CEO that, because they can reshuffle it. They can say, okay, we do think that this manager is overwhelmed, overburdened. We know that this association likes them. So let's maybe move some things around if we can, to try to keep that relationship and to try to make sure that the association is getting what we promised them. So I would really recommend talking with them, because your manager, again, just may be totally overworked, and there may not be something that they personally can do about it. You may want to go to someone higher up. Okay. So another question, this is a condo association that wants to repipe a 25-year-old community for approximately $1 million with a 10-year loan. I believe the water leaks were approximately $45,000, and the reason the association wants to repipe. How common is repiping a 25-year-old condo community, and suggestions as to how to handle the vendor selection and holding a town hall or hall meetings, and mailing a survey to the owner, since at least one owner does not have internet access. Unfortunately, old pipes are a very, very common issue that we see in communities. I can attest, I myself at this very moment am having the pipes in my house dug out, because all of our pipes stopped working last week. So I don't even live there right now. So this is a very common problem. 25 years, 30 years, I think mine are like 60 years old. So it is a very common problem. You're not seeing something that's unusual. So we'll say that. I admire, wanting to have a town hall or wanting to have a survey to get the owners involved with the process, but it is really important to remember that the board makes this decision, and the board selects the vendors, not the homeowners. This is going to sound not PC, but if you have too many owners involved, it can just be too many cooks in the kitchen. You're going to have too many opinions. You're going to try to appease too many people, and the process can become really overwhelming. And it's already a pretty strenuous process. So keep in mind that, while you can certainly notify the homeowners of what's going on, and you can even have a town meeting if you wanted to say, we think this is the best way to go about it. Does anybody have any other ideas? We recommend generally that the board takes care of it and just keeps the homeowners in the loop, so that, again, you don't have too many cooks in the kitchen. You aren't bogged down with too many opinions and make it too difficult to actually get the project done. And get your association attorney involved in this process. This is a really big project. It is a really huge one. So you want to have an attorney involved who can, again, review these contracts. We want to make sure you can take out a loan We want to make sure that all your I's are dotted, your T's are crossed, because it's a big project. It's going to cost the homeowners money, whether you get a loan, whether it's a special assessment. And so you really, really need to make sure that you're doing everything correctly for this project. So definitely reach out to your legal counsel as you get this project started. Okay, so next question. Sealed bids are used when the term of a bid needs to be confidential so that no one else sees the bid and then comes in with a lower amount. You could have bids sent to like a third party you trust who won't disclose the terms, your attorney, your CPA, even your manager. That's another way to make sure that the proposals stay confidential. And all discussions for contractor selection and hiring should be done at an open meeting. Absolutely. The only time you can really discuss those vendors, again, a current vendor, is if you're discussing their job performance, and you can discuss that in executive session. Everything else should be in an open meeting. If the entire board is meeting with contractors who you are thinking about hiring, guess what? That needs to be an open meeting. Anytime you're getting together with a quorum of the board, you need to make sure it's an open meeting. So definitely discuss everything in an open session. Make sure that you've provided proper notice to the homeowners. The odds are you're probably not going to have a lot of homeowners attend, but you want to make sure, again, that you give notice, because that's required under state law. Anytime a quorum of the board are going to be discussing something, making a decision, even if you're just meeting with a contractor, if you're having them come to you or you're going to them, you want to make sure it's a meeting that the homeowners know about. An HOA or contractor can select, HOA or contractor, an HOA or condo selects the contractor that they feel that they're the most comfortable with. It doesn't have to be the lowest bid. So I mentioned this earlier. Finding the best deal for the association doesn't necessarily mean that you should go with the lowest bid. That just may not be the right fit for you. You want to look at the contract and the services provided by the vendor in totality so that you're making sure that your needs are met, because you're trying to get a project done. You're not just trying to save the most amount of money. You're trying to get something for that money. So make sure you're looking at that. Make sure you're paying attention to the totality of the contract. And if that happens to be the lowest bid that really does fit you the best, great. That's fantastic. If it's not, that's where we can start to negotiate and try to see if there's some wiggle room with the contractor to lower the price. But you want to look at what's best for the association overall, not just what is the cheapest. Okay, so next question. If we feel the work a registered contractor did is inferior and we contact the registrar of contractors, does the organization come check on the contractor's work, or do we need to hire someone else to come look over the work? So great question. If you do file a complaint with, people call it AROC or the ROC, I'll refer to it as the ROC. The ROC is going to send out an inspector to look at the work and investigate it. It's free. You don't need to worry about the cost. And then if the work is below an acceptable standard, what's going to happen is the ROC is going to go back to your contractor and they're going to say, here's what you have to do to fix this. We've run into this issue before. Be aware that you shouldn't file a complaint with the ROC and then immediately try to hire a new vendor. I've had an association that's done that before. The ROC is going to require you to give the contractor an opportunity to correct the problems. So you have to give this process time. It is honestly, it's a great way to make sure that the contractor lives up to the terms of your contract, but just make sure you're not immediately looking for a new vendor. You're going to have to give the contractor time to repair it. And 9 times out of 10, they're going to repair it because they need to be licensed. And the ROC has the ability to suspend their license if they don't correct the work properly. So be prepared for an inspection. They'll let you know if they think the work is subpar. You can have another vendor come and look at the work and see if there are issues, but you're probably going to have to pay for them to do that. Normally, vendors only do free consultations if they think they're going to be hired. So if they know that they're investigating somebody else's work and that, there's a possibility that that contractor will still be given the opportunity to correct the work, they may be a little bit less likely to do it for free. You can certainly see, but the Registrar of Contractors, they are familiar with all scopes of work. They're trained to do this. So I think that they're your best first step to try to get that work corrected. Okay, so next question. What recourse does a tenant owner take when the HOA or manager is not evenly applying regulations? like feeling singled out over a past violation. So this is a great question. Put it in writing, write to your board. I know that generally your manager can act kind of as a gatekeeper or an intermediary between you and the board, but write to the manager and write to the board. Tell them, I feel singled out. I see all these other homes in the community that have the same violation that I feel like I'm the only one that's getting, and they're not being corrected. Make sure you notify them. Again, communication is key in these relationships. For the board, when you do receive a communication like this, don't immediately write it off. You want to make sure that you're looking into it, ask the manager, and maybe also take a drive around the community. If they specifically say, I have found, 5 other homes that also have this violation, but I think I'm the only one receiving a violation letter, then maybe take a drive around, see if that's really the case, and then talk to the manager about it. What could potentially be happening that homeowners don't see behind the scenes is maybe this homeowner feels that they're being singled out, but in reality, other homeowners are receiving these violation letters and just not correcting the violation. So I do like to remind homeowners, obviously don't give away any specific information, but I do like to remind homeowners and say, just because you're seeing a violation doesn't mean that the association and the management company aren't taking steps to address it. It's just that the owner obviously has to take the affirmative step to correct the violation. So that's something that's a good idea to remind a homeowner every once in a while, if you know that other letters are being sent out to other homeowners. If you find out that it's just this homeowner and other homeowners are also in violation of a specific provision, talk to the manager, figure out why that's happening. If you really feel like the situation as a homeowner, let me say this, if as a homeowner, you feel like the situation isn't being corrected, it's not getting better, you might want to talk with an attorney who represents homeowners against associations. They be able to give you a better assessment as to whether or not you really are being selectively targeted. And then they can also talk to you and talk to your association about what's going on. We have recommendations. Obviously, we do work with attorneys that represent homeowners. So we can give you recommendations for attorneys that we think really do a great job of representing homeowners, because homeowners need attorneys too. Something else, if the situation really doesn't correct itself, is you can go to the Arizona Department of Real Estate. So what the Arizona Department of Real Estate has done and what our state legislature has done is essentially created a quasi-judicial organization that only hears complaints between homeowners and associations. So it's vice versa. Associations can file complaints against homeowners. Owners can file complaints against associations, but it gives you a more informal environment where you can submit your complaint. And if the association responds, then you would present your case to what's called an administrative law judge, and they'll listen to each party and ultimately make a determination. And determine whether or not the association maybe isn't equitably enforcing the documents, or if they're in violation of their governing documents. It costs $500 per issue to file, but that is obviously a lot less costly than filing a lawsuit, because you're going to have to be represented by an attorney, or you may just want to be represented by an attorney. So it's a more cost-effective way to deal with these issues if you don't see them being corrected after you have notified the management company or the association. And then again, you can consider a lawsuit. Obviously, the cons are it's expensive. You might not win. And if you are suing under the terms of the contract, so if, let's say, you're claiming breach of contract, right? The CC&Rs are supposed to be fairly and equitably enforced against all owners. They're not, so that's a breach of contract. Then there's a possibility that if the opposing party, the association, is deemed the prevailing party in the lawsuit, they can ask for their attorney's fees, and the court can award a judgment and have you pay the association their attorney's fees on top of any attorney's fees you've incurred. So that's a possibility. Now, obviously, the opposite could be true. If you win the lawsuit, the association may get a judgment against it to pay your attorney's fees. Lawsuits also can be very dragged out. The benefit of the ADRE is the process does take a couple of months, but lawsuits rarely ever take a couple of months. That's just the start of them. So something to consider. If you're trying to weigh the pros and cons of a lawsuit or filing a claim with the ADRE, talk to an attorney. They'll be able to give you a better analysis for you, especially based on your specific concerns. Okay. Can Mulcahy Law Firm provide our board with recommendations for a management company? Absolutely. We would love to do this for you. Contact us because we like to base our recommendations off of your specific community. We always do that. We never give you like a carte blanche. Here are the management companies we like. So contact us. You can call me today. That's no problem. And I want to hear about your community. How many homes you have? Are you a planned community? Are you a condominium? What needs are you looking for? Everybody is looking for different needs with their management company. So contact us via email, via mail, via phone, whatever you want. But we'll be happy to give you a recommendation that is specifically based upon the needs of your community. Okay, now we have another question. What happens if the association doesn't have contracts with vendors? This is something I've come across and it's not the best situation. So the good thing about not having a contract is that makes it very easy to fire a vendor if you want to fire them. The state law doesn't impose some kind of, termination minimum. So you could let them go right then and there, and there's no contract dictating that you can't do that. That is easy. What may be bad about not having a contract is there are no requirements for the management company or the HOA or the vendor. So it's not as if you can go to the vendor and say, hey, vendor, we think that, we're unhappy with this part of your performance. And here's the section of the contract that says that you're obligated to do this. You don't have that in writing. You don't have the terms in writing. And that can make it really, really hard to work with the vendor because you're just not basing it off of anything. They can easily say, well, we never agreed to do that, or that's not in writing. So we always advise that you get a contract. Even if you have a vendor who comes to you and says, we don't need a contract, that's not something we're worried about. One, you may want to rethink that relationship with that vendor, but two, contact your legal counsel. They will draft a contract for you. You want to make sure that the association is protected. So make sure that you have that contract. We're happy to help you with that if you need it. That's a tough situation. Okay, so another kind of question. We have a contract that has a starting date and is continued annually. The same contract has a 30-day termination agreement. Would this constitute the same as having a beginning and ending date? So in our experience, what you're referring to is basically an annual renewal mechanism that basically states the contract every year is going to automatically renew. They may even have a clause in there that says that after the first 2 years, the contract's going to automatically renew and it'll increase by 2% or something like that. So that's really just a mechanism to make sure that the contract remains in place and that it's renewed without the parties having to go through the formality of renewing it. You can still terminate the contract within 30 days, despite the annual renewal provision. But again, I'm sure you're sick of me saying this, but have your attorney look at it because I've seen some that you can't terminate within a certain period of the annual renewal date. It's rare, but I have seen it before. So have your attorney look at it to make sure that you are terminating the contract appropriately. Okay, the next question is when does our association need to get involved in neighbor disputes? This is a really good question, and I know you're going to hate me for saying this, but it is super case specific. We wrote a blog post about it. We can pop it onto our chat, or you can look on our website to get it as well. It is very, very, very case specific because some issues really are better suited to the homeowners of dealing with it. And some issues we really do think the association needs to get in on it, especially if there are potential fair housing issues at play here, something involving, race, disability, sex, national origin, familiar status. Those are all things that trigger the FHA or the Fair Housing Act. So take a look at that blog. But if you have a really specific question, we recommend that you talk to your legal counsel because whether you should get involved or not is very, very case specific. So get in touch with the legal counsel. Okay, next question. Timeline for soliciting bids and then opening the bids. So this kind of depends on the situation you're in. Sometimes you're going to need work to start a lot quicker. And sometimes, you're looking into a contractor or a vendor that you're going to have, start work in like 6 months. So it depends on the situation that you're in. But other times you're going to have a lot more time to really think about it, be a lot more careful and meticulous about the process. Ideally, it would be nice to make sure that you have like a full 30 days to review the bids, solicit the bids, and make sure that you can have a meeting with the board and discuss your options in detail. Send out your RFP within 30 days, give the contractors about 2 weeks to submit the bids. Sometimes it can take them a while, especially right now. I don't know about your neighborhoods, but my neighborhood, everybody's doing work on their home. So I know contractors are slammed right now. So give them a little bit extra time to get back to you. Have interviews in an open board meeting. Again, make sure that homeowners can attend if they want to, and then have an open board meeting to make the decision as to which vendor you're going to hire. So given all those steps that we recommend, at a minimum 30 days. If you are on a tighter timeline, that's the timeline that you have, but try to plan it out so that you have at least 30 days. Okay, next question. What can you do when a homeowner has too large a tree in their patio area and it's causing problems with a shared wall cracking, and you're concerned with the roots and that they could affect water lines? It isn't addressed in your CC&Rs. I've actually dealt with this situation last year, this exact same situation. So reach out to your attorney. There probably is language in your CC&Rs that you can rely on that maybe you're not seeing. So reach out to your attorney so they can look through your CC&Rs, your governing documents, because generally a homeowner cannot allow something to exist on their property that's going to damage common elements or damage another owner's lot. So the association could have the ability to, start writing letters and saying, we're seeing that your tree is causing damage to our common wall, which all the homeowners are responsible for, or maybe the homeowner and the neighboring property are responsible for that. But you want to make sure that you reach out to that person, let them know what's going on. Look at who's responsible for the maintenance of the tree. If it's the homeowner, then they might need to remove the tree, cut it down, whatever needs to be done. If it's the association, then the association may be able to take action. It sounds like if this is in a patio situation, that it might be enclosed and might more likely be the homeowner's responsibility, but have an attorney look. I can't tell you how many associations I have dealt with that contact me and say, this person's tree is causing a problem. We want you to write them a letter and tell them that they have to remove it. And so I look at the CC&Rs and I say, hey, do you know actually you're responsible for this tree? So definitely have your attorney look at it so you make sure that you know who is responsible for maintaining the tree and potentially removing it, or cutting the roots, whatever is necessary. Without your CC&Rs, I can't give you a better answer. I'm sorry that I keep saying contact your attorney, but it's the nature of the game. So contact your attorney, ask them the questions, make sure that they can review your CC&Rs so that they can give you a very educated answer, and give you, hopefully a solution. Okay, so next question. We have an emergency gate closed. We would like to enclose the side entrance with a block fence to eliminate pedestrians walking through. Who do we contact? Check the city that you're in and the fire department before you do that. They are going to have the final say over any kind of emergency access. So contact your city. Planning and development department should be able to help you with this as well. And also contact the fire department because it may be a no-go. You may not be able to fence that in if you want to. Okay, next question. We're almost there, guys, I promise. Thanks for hanging in with me. Do you recommend getting new bids from vendors every 5 to 7 years, even if you are not currently having major problems? This is a great question. So this really depends. Sometimes yes, sometimes no. If you're happy with the vendor and they really are meeting your expectations, it probably isn't necessary. You may want to, I suppose, snoop around and see what other associations are paying the vendor, to make sure that what you're paying is fair and reasonable given the conditions of the market. Keep in mind that, I mentioned those renewal provisions a couple questions ago. Keep in mind that it is very common for the cost for a vendor to go up the longer that you work with them. And again, if you have a good relationship, you want to foster and continue to allow that relationship to grow. That may mean that you're paying a little more than you did when they initially started. But if you're really happy with them, if they really are meeting all of your needs, I don't think it's necessary for you to go meet anybody else. Like I said, you can see if there's some wiggle room regarding the contract. There might not be as much as when you're first starting, but that's something that you could look at. And remember, if you are doing this, to be careful. Your vendor, especially if you have a good relationship with them, because remember, it is a relationship, they could be kind of offended if you go and snoop around for other prices or try to see what other people are doing, especially if they really feel like they're doing a good job. So be cognizant of that if you do try to reach out to other people and see what their prices are. Because again, vendors also talk. They also talk about the associations and things like that. So make sure that you're careful if you do that. Okay, so our last question, guys. As a self-managed association, a self-managed community, considering hiring a management company, which I know little about, what management company the board, or with a management company, the board still needs to do the vetting of contractors, or does the management company make recommendations based on their experience? This is another really good question. If your board hires a management company, the management company will help you with getting bids. So basically, what you can do is, let's say the board members, you are obviously always welcome to ask your manager for recommendations, especially if they work with multiple associations. They will have worked with a lot of vendors and they have a lot of experience. So they could be a really valuable resource for you. And then if the board settles on 5 vendors that you are interested in, you can then ask your manager to be the individual who goes and gets those bids from those vendors. So that can be really, really helpful. Something to consider though is that the board is the one that ultimately makes this decision. The management doesn't tell you who you're going to hire. They work for you. So make sure, even if they tell you, I work with this person, I love them, they're amazing in all my communities, but for whatever reason, you just don't think they're going to meet the needs of your community, you have the ultimate say. The board says who gets hired. So keep that in mind, but your manager can be very, very helpful throughout the process. They can manage the bids for you. When you want to meet with the contractors, they can schedule a meeting. It's one of the reasons that having a manager is so helpful, because they can take kind of a lot off of your plate, that busy work, and you can focus on the bigger picture. You can review the bids, you can ask the questions at the meeting, and it can make the process a lot easier for you. Okay. Well, that was our last question. Good questions, guys. You guys had great questions today, really insightful. Thank you for being here. Every time you attend these classes, I know that this is taking time out of your lives and your daily schedules to be here and listen to me chatter. But just know that you're doing it to make your communities better. And this information will be so helpful and so beneficial for you and make your life on the board easier, and therefore make the lives of your residents easier and make it better for them. So we thank you for being here. We also want to especially thank the Neighborhood Services Departments for Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, Tempe, and all of you others out there who are tuning in from other neighborhoods. Thank you so much. We always love working with all of you. We wish we could still see you in person, but we do love being here online with you as well. And we want to also remind you that you can join us on Tuesday, June 15th. So that's going to be our last spring session class for our next class. It's going to be a special class because we're going to be answering all of your legal questions, big or small, and the class won't end until we answer all of them. If you want to ask us a legal question, or you want to listen on other people's legal questions, because why not? I mean, why not figure out what other associations are dealing with? We may already be answering a question that deals with something that you have a question about. Tune in. It'll be super helpful, super informative. So bring your question, think about it until June 15th, and then get it over to us, and we'll be happy to answer them. In the near future, we're going to be announcing our virtual class sessions for the second half of 2021. We try to be on the ball about that. So check our website. You'll receive emails in the future if you receive emails from us, but we're always posting our classes and making sure that you know about them. And thank you so much for tuning in. Again, if you have a question, or you want a request for a bid, or you want to talk about management companies, call me. I'm here for you. I'm happy to talk with you. And thank you so much for tuning in today. Bye, everybody.